Cases heard before the Washington State Supreme Court have no juries. Only the 9 men and women elected to the court. There are no witnesses, just attorneys arguing for and against a position in open court. No one is found guilty or innocent. Instead, basic points of law are determined. As the highest court in the state's judicial system, it alone can pick and choose which cases will be heard. Every year, more than 1,000 seek review. About 100 are chosen. What follows is the true story of one case before the court. March 10, 1994, began like any other day for Kevin Gardner of Spokane. He kissed his wife and children goodbye and left for his job at Loomis Armored Incorporated, where he had worked as a driver guard for nearly 11 years. That morning, Gardner and his partner, Stephen Saboski, drove to a Sea First Bank branch on North Division. When they arrived, Saboski entered the bank. Gardner remained behind inside the truck. Moments later, the branch manager ran out the front door, chased by a man wielding a knife. Help me," she screamed as she ran past the armored truck. Gardner jumped out, but by the time he got around the vehicle, the assailant had taken another woman hostage and was holding the knife to her throat. He dragged her back into the bank, with Gardner in pursuit. Inside, Saboski drew his gun and pointed it at the assailant, who became distracted. Gardner and a construction worker then tackled and disarmed him. The woman was unhurt.
When I got out of the truck, I knew at the time that I was breaking a company policy. And it's a policy that I agree with. I think it's there for our own protection. There's been cases where people have been lured out of the truck and then shot. But I didn't see anyone else in a position to help, and I didn't see that I had any choices. And that was what was hard about being fired, was that I didn't feel like I could do anything but what I did.
When Kevin first came to see me, it was clear to me that from society's perspective, it was wrong that he be fired under these circumstances. But legally, the issue was less clear. Legally, an employer can discharge an employee, generally speaking, for any reason or no reason at any time. In this case, that was particularly true because Kevin had violated a fundamental work rule that Loomis had in place for the safety of its drivers. So in this case, the challenge was to develop a legal theory to demonstrate that terminating his employment under these circumstances violated public policy. We had the option to file suit in Spokane County Superior Court or in Federal District Court. Federal Court was available to us because Kevin is a resident of the state of Washington and Loomis is a Texas corporation. We chose to file in Federal Court because cases move faster there because they handle less volume there. Even though we filed in Federal Court, the Federal Court had to apply Washington law to resolve the issue because the employment relationship was centered in the state of Washington. So the Federal District Court judge looked to the State Supreme Court for guidance on this issue. He sent a certified question to the State Supreme Court. The question that he certified was whether a company contravenes or violates public policy if it fires an employee for breaking a company rule in order to go to the assistance of a citizen who is in danger of serious physical injury or death. After the Supreme Court answered that question, the case could be sent back to Federal Court. So we were headed to the State Supreme Court, or I hoped we were.
Certified questions from other courts, like the one in the Gardner case, are not the norm in the Supreme Court. In fact, out of the 140 or so cases the court hears every year, you can count on one hand the number of certified questions the court agrees to answer. The usual way we receive cases is either directly from the Superior Court or from one of the state's appellate courts.
The state Supreme Court is a unique court. We're different than the trial courts like the Superior Court, where you have a judge and testimony is presented, witnesses appear, and a jury might resolve the issue. From the trial court decision, a losing party has a right to appeal to the State Court of Appeals, which must resolve that case. The state Supreme Court is a discretionary court and only takes those unresolved legal issues that we choose to take.
Of course, the Supreme Court does not have to, nor can it, accept all of the 1,000 plus cases that apply to be heard every year, including certified questions from other courts, as in Gardner versus Loomis.
If Kevin Gardner were to receive his proverbial day in court, the Supreme Court would have to agree to give it to him, in competition with hundreds of other requests. Those requests come into the court through the Commissioner's office, the Supreme Court's own in-house staff of lawyers. The Commissioner's office prepares background materials for the justices, including briefs, part of the record from the lower court, and a recommending memo. The justices then meet in private and reach a decision.
Well, there are certain cases this court must take, such as death penalty appeals, but beyond that, we largely have discretionary review authority. In exercising that discretion, we look for cases of great public importance where there's a need for a prompt determination. We look for cases where a trial court has struck down a statute, a tax, or an ordinance on constitutional grounds. And finally, we look for cases in areas where the law is uncertain or unclear.
I wasn't certain, but I was fairly confident that the court would accept our case. It usually accepts certified questions.
The Supreme Court did decide to hear the certified question on the Kevin Gardner case. After the court selected a date for oral arguments, it chose a reporting judge, someone who would take the responsibility for writing the decision of the court or the majority opinion, assuming a majority of the justices agreed with him or her. Reporting judges on the Washington Supreme Court are chosen at random, but with an equal distribution of workload assured. The names of the assigned justices are never made public. In Kevin Gardner's case, the name chosen was Justice James Dolliver. Dolliver was a seasoned veteran, having served on the High Court since May of 1976, when he was appointed by Governor Dan Evans, for whom he served as Chief of Staff for 11 years. A reporting judge's first task is to prepare a pre-hearing memorandum, a document circulated to all justices that includes an overview of the case. Typically, it is distributed about a week before the oral argument. Much of the work is often performed by one of the two lawyers assigned to each justice. They're called law clerks. Many years before, Justice Dolliver himself had served in this capacity.
The clerk's office, which assigns hearing dates for all cases, notified us that our oral argument would be on October 27, 1995. This is the point where I started to get nervous. I'd been before the court a few times before, but this is the Supreme Court, the court of last resort, the highest court in the state.
As the state's highest court, the Supreme Court's most important function is its case law decision-making process. It's here the parties bring their dispute to the court to resolve. The court resolves that dispute in a written opinion, and those written opinions become guideposts for future decision-making, almost on a principle of been there, done that, for purposes of deciding future kinds of cases of a similar nature.
It wasn't just that it was the Supreme Court. There was a lot on the line for Kevin Gardner and his family. He'd lost his job and his livelihood. And as we got further along in the case, the legal issue became more difficult and complex. I didn't know which way the court would go.
May I proceed? Yes. Thank you, Your Honor. May it please the court, my name is Paul Burns. It's my privilege to represent the plaintiffs in this case, Kevin and Terry Gardner.
We were vulnerable. We were arguing that someone shouldn't be fired for saving somebody's life. But on the other hand, Washington law was clear that an employer has a duty to provide a safe place to work to all its employees. And that was the basis of the company's work rule. We never challenged the validity of the work rule.
And our argument in terms of it being consistent with public policy really flows from Loomis's statutory obligation under Washington law to provide a safe and healthful place of employment. Loomis is required under the statutes that we cited in our brief to provide a safe and healthful place of employment, to ensure that its employees do not work under conditions that are detrimental to their health, and also Loomis employees are required to follow occupational safety and health law. And so what will happen is Loomis can promulgate this work rule, and it's consistent with Washington law. It's intended to save the lives of its employees and the public. And what happens if there's a tension here between Mr. Gardner's case, where he's suing for wrongful termination violation of public policy, yet Loomis, on the other hand, is trying to comply with Washington?
One of the good reasons behind the work rule was to prevent drivers from being lured out of the truck by a ruse of some sort.
The reality of life in the 90s is there are a lot of criminals, and it sounds like I'm being unrealistic, but not in this industry. I've represented this company for 4 years, and criminals use a variety of ruses, and there are a lot of people who will do whatever they can to lure people out of these trucks, and these people in the armored car industry are regularly involved in criminal situations and shootouts and deaths. And it happened here in Linwood in 1991, February 1991, where a Loomis guard got out of the truck. He violated the work rule, and he was shot and killed. Had he stayed in that truck, by the way, he got out of the truck to assist his partner, who he believed was in a criminal situation. And he got out of the truck, and he didn't see the accomplice, and he was shot and killed. Had he stayed in the truck, he wouldn't have been killed, obviously. He could have called 911. He could have taken a variety of means at his disposal to try to stop the situation.
A visitor to the Supreme Court will not see witnesses in the courtroom. Unlike a superior court or another trial court in the state, one will see witnesses because it's the job of the trial court to make findings of fact based on what the witnesses testify to. The Supreme Court's job, on the other hand, is not to make findings of fact, but to determine the law. And that is the reason that the Supreme Court has no need to hear witnesses. We accept as true the findings that were made by the trial courts and the courts below.
Kevin didn't have the option of arguing that the work rule didn't make sense or even that he didn't know about it.
Also, a fact that has been largely overlooked in this case, and I believe to be very significant, is Kevin Gardner was a union member, and the record reflects that. He was on the union negotiating committee. The work rule in question is embodied in the employee handbook. That employee handbook is incorporated into the collective bargaining agreement. When he was fired for violating company policy. The collective bargaining agreement provides that Loomis can terminate employees for violating a work rule or regulation. And the union, when it negotiates the collective bargaining agreement, is aware of Loomis's work rule.
My opposing counsel, Mr. Folan, for whom I have a great deal of respect, was clearly making headway with the court.
Public policy tells us that we ought to physically present ourselves to danger to rescue somebody. Justice Talmadge read from a statute which indicates that you have a duty to do something. You have to call the police, you have to do something. And Loomis clearly wants their employees to do something. But to say that public policy dictates that we ought to physically incur our own harm, potentially, I'm not sure that is public policy.
Sometimes lawyers come to court with a 30-minute prepared statement to tell the court everything of importance about their case, but they never get a chance to give it because we interrupt them with questions. Some of the questions are really tough questions to point out a weakness in their case. Other questions are softballs, which we really hate to see the lawyer fumble. But mostly we ask questions so that they can refocus their argument on the aspects of the case that are most important to the court.
My concern really has to do with something that Justice Johnson really has articulated best, and that is we leave this then up to the individual discretion of the employee. Do I want to take a chance in this situation that I'm wrong, that I may be wrong and I may be fired? That is, it wasn't really a hostage situation. In fact, the person who was chasing the bank manager with the knife was only doing that to get me to respond, thinking that maybe I would have this big heart and I would get out and do that instead of sounding my siren. If we put it in the hands of the individual employee to make that decision, I'll take the risk of being wrong and then I get fired, but if I'm right, then I won't be fired. Don't we put in danger everyone else in the situation?
In my head, I had doubts and concerns about the legal issues in the case, but in my heart, I knew we were right.
For
God's sake, don't terminate a man because he goes and keeps a woman from getting her throat slit. I don't mean to be emotional, Your Honors, but this is an emotional case. It cries out for that kind of analysis. If that woman had her throat slit, we'd be arguing a different case.
On the same day of the Gardner oral arguments, the justices remove their robes and retreat to conference in a private space behind the courtroom. It is time to try to reach a decision. No one other than the 9 justices is allowed in the room. Custom and established ritual will now play a role.
It is traditional and consistent with the Old English common law that judges at appellate courts retire after hearing argument to deliberate in confidence or in secret. This allows the judges to express themselves fully and completely without outside interference and without fear that what they think and say in a closed conference may be distorted or otherwise misinterpreted. This is the way we reach our decisions.
Chief Justice Barbara Durham presides and asks the reporting judge, Justice Dolliver, to share his recommendations. The chief, as she is called, then asks if there is any disagreement. There is. Seemingly, the Gardner case will not be unanimous. She then calls on each justice for comment. Movement around the table is always counterclockwise. The chief casts her vote last. If the reporting judge's recommendation prevails, he will write the majority opinion.
After conference, the process is far from over. Assuming the reporting justice has 5 votes, including his or hers, then the reporting justice writes the majority opinion. It is then circulated to all members of the court. If there is a dissent, that dissent is circulated with all members of the court. Sometimes the dissent is so persuasive it becomes the majority and must be rewritten as the majority. In the final analysis, 5 votes constitutes a majority, and once a case has 5 votes, the decision is issued.
They are careful, and it is not easy. After all, the decision, their written word, will not only affect Kevin Gardner very directly, it becomes the law of the land. The process can take weeks and even months. In fact, it does. Kevin Gardner and his attorney, Paul Burns, wait and wait, while every Thursday morning, someone from the clerk's office walks out to an inconspicuous table in the Temple of Justice and posts the court's latest decisions. Insiders call it put on the spindle. There is no advance notice sent or press calls made about which decisions are finally being issued.
You wait and wait, wondering what the decision is going to be. And it's hard. It's hard to wait. You try to do things to forget about it, but it keeps getting brought up everywhere you go. So that's the hard part.
It can take time for this court to issue a decision. The cases we take are difficult and complex. There are differing views on the interpretation of the law in the case before us. It is important for us to take the time to get it right.
At the same time the decisions are put on the spindle, they are also posted on the internet, where the court maintains the posting for 6 months. TVW, the statewide network that televises all oral arguments before the court, also makes the decisions available on a permanent basis at its website, as well as the audio of all oral arguments.
Please the court. My name is Paul Burns.
After the opinion is issued, the judge should say nothing more. The reason for that being that the public should not get the idea there is something beyond the opinion that the judge really meant. What you really mean is in the opinion, nothing more, nothing less. Now, if your articles want to go beyond that and say what you really meant, that's their business. But as far as the judge is concerned, what the judge says in that opinion should be the end of it.
One of the hard things about waiting is that it just feels like all your plans are up in the air. You don't have any idea where things are going, and maybe the worst part is you don't feel like you have any control over it.
We argued the case in late October 1995. I didn't expect an answer right away. When Thanksgiving came and went and Christmas came and went, I wasn't surprised. But as we moved into the spring, I got more and more anxious. We were calling the Supreme Court every Thursday to see if it had been filed.
Another hard thing about waiting is that you don't really have any idea how it's going to turn out. And so really about all you can do is sit and you wait and you pray and you pray.
Finally, on April 4th, 1996, at 8 a.m., almost 6 months after the oral argument, and more than 2 years after Kevin Gardner jumped out of his truck, his wait was over. In an 8-1 decision, the court sided with Kevin. In his concurrence with Justice Dolliver's majority opinion, Justice Richard Guy, a native of Spokane, wrote,
"In this case, Mr. Gardner was faced with a decision whether to break what is normally a sensible and reasonable rule for his own and his partner's safety and save a woman's life, or adhere to the rule and watch a woman he knew be murdered in front of him while he sat safely in his truck with gun in hand. It defies what I believe is true about human nature that anyone would be willing to watch a person die in order to comply with a company safety rule. I believe our nature would cause any decent person under these dire circumstances to break the rule and save the life. Even normally good rules must have exceptions and yield to a higher good."
The measure of Kevin Gardner is what he did after he subdued the assailant. The man was obviously troubled. Kevin had him pinned to the ground and held him there, and he said, "Relax, relax, this is going to be all right. This will be okay."
I really didn't do anything special.
Kevin Gardner never returned to Loomis. He eventually settled out of court. By agreement, the terms of the settlement between the parties are sealed. Kevin and his wife Terry and their children Eli and Kendra continue to live in Spokane. He has dreams of becoming a teacher.
Oh, beautiful for spacious skies, for amber waves of grain, for purple mountains, majesties above the fruited plain. America, America, God shed His grace on thee, and crown thy good with brotherhood from sea to shining sea. America, America, God shed His grace on thee, and crown thy good with brotherhood from sea to shining sea.
You guys want to sing it now?